We're with Ryan Tegnalia. He's a criminal defense attorney in San Diego, California. He's agreed to answer some online questions that were posted specifically related to domestic violence. With that said, Ryan, let's get into the questions. The first question that was posted was, I was exchanging my daughter with my ex-wife, and things got a little heated in the exchange. The police were called, and I was arrested for domestic violence. I haven't been with my ex-wife in several years. Are the charges for domestic violence correct?
Okay, well, yeah, once again, domestic violence is one of those areas of law that the only difference between it and other areas of violent crime are the nature of the relationship between the defendant and the alleged victim. And what happens in cases like this is a very common question. The romantic relationship is over, and so the person's wondering why they're charged with domestic violence, whereas the common understanding is that domestic violence is between girlfriends, boyfriends, and spouses. The penal code that defines what a domestic violence relationship is does include former spouses and parents of children. So even if the romantic relationship itself is over, a domestic violence charge, depending on the facts of the case, could still be appropriate, again, even if you're not dating or still together.
Okay, makes sense. Next question was, I was served with a criminal protective order and was told I had to leave my own house. Is there anything I can do about that when I go to court next week?
Well, yes and no. Unfortunately, this is a common situation, and it's also one of the big stressors that people dealing with a domestic violence case have, is oftentimes there is a move-out order, or rather just the 100 yards stay-away order keeps the person from being in their house. They oftentimes don't have enough money to rent another apartment or another home, and there are issues providing with the family. So it is very important to address these issues early before the financial obstacle can just become insurmountable. The answer is yes. There are a couple things you can do. You can try calling the sheriff's department and see if they'll do what's called a keep the peace order, where they show up at the house, your wife or girlfriend leaves while you get some things, some items for yourself, toothbrush and shampoo and all that stuff, if that's what you're looking for. As far as like being able to permanently move back into the house, that is something you're going to want to discuss with your attorney, because usually when the case is just getting started, the judge will leave the stay away order in place, meaning you're not allowed to be in the house if she's there. However, you can alter that, and an experienced attorney will know how to get that order altered much quicker than someone who doesn't know what they're doing. You can have the judge address the order even when there's no court date currently set. There are ways to go about doing that. And there are also some things you may be able to do at the very first court appearance. But there are a lot of steps that most judges want to see for them to consider allowing you to move back into the house or have contact with the alleged victim. And so in that sense, it is important to have an attorney who's experienced with domestic violence cases so that you can complete those steps as quickly as possible and be reunited with your loved one.
Okay. Next question we had is, my girlfriend says she's going to drop the charges. Do I even need to go to court?
This is one of the most common questions we get, and it's actually going to lead into an answer that actually applies to all criminal charges. What a lot of people don't understand, the police and the victims of crimes do not charge people with criminal offenses. The way it works is the police agency investigates the alleged crime. They then send over all of their materials, witness statements, any physical evidence, photos, over to either the district attorney's office, or on misdemeanor cases within the city limits of San Diego, to the city attorney's office. An attorney that works for the government then looks at the facts of the case, and they decide whether or not to formally issue charges against you. The victim does not have standing to drop the charges. They can certainly let the prosecutor know that they're not interested in pursuing a criminal case, and the prosecutor will take that into account when deciding whether or not to formally charge the person who is arrested, but they can't just drop it. So the answer is yes, you do have to go to court. But that being said, sometimes an attorney can help you to convince the prosecutor to not file charges. So you do want to call a defense attorney as soon as you can, and as soon as you've been arrested and hopefully bailed out.
Gotcha. Next question was, oh, actually, Ryan, can you turn down your volume a little bit? It's starting to pick up whenever I'm talking, just slightly down a little bit on your computer there. If you can.
Okay.
Okay. Next question we had was, what is a no negative contact order?
Okay, this kind of ties into the question 2 questions ago. So there's a stay away order, and then there's a no negative contact order when we're talking about the overall restraining order that's issued in domestic violence cases. A stay away order is usually 100 yards, and what it says is that you are not allowed to be within 100 yards of the alleged victim of the crime. And again, this leads to a lot of negative consequences. You might have to move out of your house. If you have a child together, it's difficult to discuss matters relating to the children because you can't talk to them, and you're not allowed to have any contact at all. A no negative contact order is exactly that. You're allowed to have contact with the person as long as it's not negative. So you're not allowed to, harass, threaten, strike, yell at essentially or berate the individual, but as long as it's peaceful communications, you're allowed to physically be around them, which allows you to move back into your home, and you're allowed to call them, which allows you to arrange, things as far as the children and the family finances. So getting a no negative contact order as opposed to the full stay away order is a priority for many people charged with domestic violence. And like I explained a few minutes ago, you need an attorney that knows how to put the parts in place that the judge is going to want to see before they're willing to alter the order to a no negative contact.
Okay. Next question we had is, I was arrested for a felony on a $50,000 bail, but when I went to court, I was told it was a misdemeanor. First portion of this is, can they do that? And if so, can I get some of the money back from the bail bondsman since my charges were lowered?
Okay, well, the answer to the first part is yes, they can do that. Like I explained a little bit ago, it's up to the lawyer that works for the government, be it a city attorney or a district attorney, to decide what to charge you with. They can charge you with a lower charge than what the officer recommended and booked you in on, or they can charge you with a greater one. So if the officer booked you in on a misdemeanor and the prosecutor thinks it's a felony, they can raise it. You then go to court, and it's possible the prosecutor asks to raise your bail, in which case you're put back into custody until you post the additional amount. So the prosecutor's office does have absolute discretion on what to charge you with. For whatever reason, in domestic violence cases, we see this fairly commonly, where the officer will book the individual in on felony charges with $50,000 bail, and then it's ultimately charged as a misdemeanor. An experienced attorney will be able to tell you that right away. And so it's important to call one because it's possible you save a lot of money as far as bailing out on a lower schedule. As to whether or not your bail bondsman is going to give you any money back, you need to contact your bail bondsman and ask them and tell them what happened. They did post a $50,000 bond, so they performed what you contracted them to do. If you're on a payment plan or whatever, that's just something you need to discuss with them. And hopefully your attorney recommended a bail bondsman that is honest and trustworthy and will work with you.
Okay. Final question we had was, while my case was going on, I was able to get a no negative contact order and be around my girlfriend and or son. At my last hearing, I got a plea deal, and now the restraining order is back. Is that right?
Okay, it sounds like you were probably charged in the city of San Diego. This is fairly common. What the nature of the restraining order is up to the judge. The judge issues the orders as far as the no negative contact versus the stay away that we've been discussing, and the judge can alter the order at their discretion. However, if you enter into a plea deal, it's not uncommon for the prosecutor's office to make a full-blown protective order a condition of that plea deal, and they are allowed to do that. Now, if the judge already granted a no negative contact order, it is sometimes fairly easy to get the no negative contact order back. However, on the day that you enter into the plea agreement, the prosecutor can make you stipulate to a protective order as part of your plea deal, and then you just have to address it again later. And so that is something you would need to discuss with your attorney. It is something they're allowed to do.
Okay, excellent. Well, if you have any other questions for Ryan, you can just post them in the comments sections below, and he's agreed to get back to you with answers. And thanks for your time, Ryan.
Yeah, thank you. And if anyone has any questions about a domestic violence case, like I said, an important part of it can be contacting a lawyer early. Feel free to give me a call at 619-577-0868. I'd be more than happy to talk to you. Thanks, Ryan. I'll talk to you next time.
Thanks.